Welcome to Free Law School. My name is Gregory Swafford, and we're going to be talking about most businesses are built backwards. Conversation is about structure, business structure, and why most businesses are built backwards. That's what we're going to talk about, and whether or not you have given any consideration as to whether your assets and risk should be separated in your business. Have you considered whether assets and risk should be separated? That's what we're talking about. Let's see if we can get a few others here in the conversation. Most businesses are not built wrong, they're just built in the wrong order. The problem is nobody realizes that until something goes wrong, like a lawsuit, a dispute, creditor, contract problem. That's when people find out whether or not their business structure actually works or whether they're just holding paperwork. Here's a question that exposes your exposure. And that question is, if someone sued you today, what could they take? Think about that for a minute. We're talking about business structure and the fact that most businesses are built backwards. If someone sued you today, what could they take? Let me say this early so we all can be on the same page and we're not wasting each other's time. This conversation isn't about funding strategies. It isn't about how to secure a grant. It's not about credit strategies. Those conversations are tactics. And the internet and social media has hijacked the conversation about business structure. Business structure has absolutely nothing to do with any of those things. Business structure is about what survives under pressure. What happens when something goes wrong? We're going to get into it. We're going to talk about limited liability protection because that's at the heart of business structure. What happens when something goes wrong? Who controls the business? Tax implications for the selection or type of entity chosen. We're going to get into all of those things. But again, this is not about business credit. It's not about grants. It's not about hacks or funding strategies. Those things are all tactics. And now, let me say this, they're not bad things in and of themselves, but those are things that the business owner, the entrepreneur, should be thinking about after structure and order is in place. Those are optimization tools. Order precedes optimization. It's important that we understand that. That's something totally separate from business structure. If we don't implement the proper structure, then everything is leaking out. And all we've done is scaled the exposure, opened ourselves up personally to greater exposure because there is no structure. So we want to deal with the issue of structure primarily. What is business structure? What's it about? Well, at the core, it's about the legal and operational framework of the business. That framework is going to determine how the company is organized, who owns it, and how it's taxed. It's like the DNA of the business. Think of it in that way. The DNA of the business. It dictates how the business interacts with the government, with the public, as well as with the owners. If you're just joining us, the conversation is most businesses are built backwards. Most businesses are built backwards. Now, we're going to get into it. Put it in the chat. Let me know where you're joining from. We like to know those things. Where are you joining from? And what's your business industry? What industry are you operating in? Business structure. Now, maybe some of you guys are actually getting ready to launch something. Maybe you're operating a business. There, no matter what jurisdiction you're in here in the United States, there is no requirement that you even form a business entity. Many people form or operate without forming a business entity. That's called the sole proprietorship. Now, it's not advisable, and here's why. The sole proprietorship doesn't provide any protection, no separation. That means if the business engages in activity and that activity causes injury or harm, then the business owner's personal assets will be at risk in order to satisfy that judgment that's rendered. That means that your home can be seized, your vehicle, bank accounts. If it's a side hustle and you have a salary somewhere, that salary will be subject to garnishment in order to satisfy the judgment. That's why we form business entities to separate our personal assets from any business risk. The law says that if we decide, and the reason for this is when the entrepreneur decides to start a business, engage in business activity, the purpose for the protection is to prevent the seizure or sale of any or placing at risk any of the things that you already own, your personal assets. Your personal assets does not have to get dragged into a potential liability situation because you're going into business. But you have to set it up properly in order to get the protection. That's why we form the business. Many business owners think that the business is formed for the purpose of starting a business, or the entity is formed for the purpose of starting a business. That's really not it. If anything, that's incidental, but that's not it. We form the business, or there is the availability in order to protect your personal assets. And that is called separation. Separating the business owner from the business, separating you in your personal capacity from you business owner in your business capacity. That's the reason that we do that. The next form of business is the partnership. The partnership provides no protection. The general partnership, it provides no protection. It is two or more people sharing risk. Everybody's exposed. Now, there are different types of partnerships. There is the general partnership, and then there's the limited partnership. In a limited partnership, there is some protection. The protection goes to the limited partner. The general partner is the person who operates and controls the business activity. The limited partner does not exercise any control or participate in the business operations. That person has merely invested. So that person is going to enjoy some limited liability protection as long as they don't get involved in the operations of the business. Next up is that default entity that most of you guys have. That's the LLC, the limited liability company. And the limited liability company, it provides that protection. It's basically formed as a hybrid between the sole proprietorship and the corporation. That means that there is a pass-through tax treatment because with the sole proprietor, any income or loss that's realized, it's carried on the business owner's personal income tax return. Okay. So the LLC gives us that benefit that we get the pass through tax treatment as well as the limited liability protection, meaning that the personal assets are safe from any business liability. The reason why that's important is based upon the next type of entity, and that's the corporation. So many people decided to form the LLC, one, because it's easy to maintain, and number two, because you avoid dual taxation. The corporation gets taxed twice. The profits are taxed, and then when the corporation declares dividend payments, meaning pays the shareholders their proportionate share of the profits, those shareholders then have to report that income on their personal tax returns. Therein, we have the double taxation. Now, as it relates to limited liability protection, there is no difference between the corporation and the LLC. Limited liability has the same meaning within the context of both, but it's not automatic. The separation has to occur, and that is a conscious effort. When we form the LLC or the corporation, here's something I want to tell you guys this from the beginning. And this is one of the biggest misconceptions and myths associated with business structure. And it's that all you have to do is form an LLC or a corporation and you're protected. That's not the truth. Nothing could be further from the truth in actuality. Filing an LLC, forming an LLC or a corporation provides no protection. None. Now, I know it's get the LLC, check the box, get an EIN, open a bank account, and you're done. That's not the way that it works. And so many business owners have fallen into that trap and they don't even realize that it's a problem that they've actually boxed themselves in with no protection until it's too late. And the reason is because business structure is only tested under pressure. It's not tested in the calm periods. It's only tested under pressure. That means when the lawsuit shows up, the partnership conflict, the credit default, employee dispute, it shows up under pressure. Those are just some of the pressure events. Now, your business is being classified on a daily basis. Each time the business owner enters into a transaction or takes some kind of business action, those transactions or action sends out a signal. And that signal is used to determine whether or not the business is personal or whether it's separate. That's the purpose behind the LLC. It has one purpose or the corporation, to separate the business owner from the potential liability. In order to do that, the business owner must remain separate from the business. How is that accomplished? That's accomplished through business behavior. Again, how the business moves, whether or not the owner signs things in a personal capacity, whether you're signing business contracts on behalf of the business, or whether the business owner is signing in his or her personal name, personal capacity. How are we signing contracts? Does the business owner guarantee or act as a guarantor for loans for the business? That sends out a personal signal. If there's a problem, does the business owner step in and resolve the problem from a personal standpoint? All of those things send out a personal signal. How does the money move in the business? Is there a mixing of personal and business funds? If there are cash flow issues, does the owner inject personal funds into the business bank account in order to cover any shortfalls? The business is being interpreted on a daily basis by any number of institutions. We're talking about banks, courts, insurance companies, investors, regulators. All of those institutions are trying to make a determination about the business. They have no idea. They don't know the business owner personally. And they all have their own particular rules and the way they look at things. But they share one very important thing in common. They're all trying to determine whether or not the business operates independently of the owner or whether the business is actually dependent on the owner. That's what they want to know. Now, if you're just joining us, we're talking about most businesses are built backwards. And the question that potentially exposes any exposure that the business owner has for tonight, that question is, if you were sued today, what could they take from you? Reflect on that. If you were sued today, what could be taken from you? Are your assets and risk in the same place? And if you're actually operating a business right now, did you give any thought as to whether or not assets and risk should be separated? We're going to talk about what that looks like from an operational standpoint. From an optimal standpoint, the business owner needs a layered structure. That's what we're aiming for, the layered structure. If everything you own is in that single entity, the single LLC, or the single corp or that corporation, then there is a potential for risk. There is a potential for exposure. Let me explain that. When we form the LLC, the purpose is to protect the personal assets, to separate the personal assets from the business liability. Now, if you only have that single entity, that LLC, and that's what most business owners have because that's what we've been taught. That's what you guys have been taught. That's what you've seen operate. Get the LLC and you're good. You don't need anything else. Well, that LLC is only going to protect your personal assets. But there is still the potential for exposure when it comes to your valuable business assets because those valuable business assets are still exposed to the operational risk. So that's the reason why we need the layering because the personal assets are here, separated from the business risk by the LLC, but contingent upon you, the business owner, operating in a proper manner. That means that you're not mixing money, you're not signing in your personal capacity, you're not absorbing risk, preventing things from escalating by stepping in from a personal standpoint. You're not using assets titled in your personal name to operate the business. That is what your personal liability protection is based upon. Now, many business owners have the LLC, but they're not operating in a proper manner. All of those things that I just described to you, those things are what we call structural drift. That's where the business owner, despite what's in the documents and the paperwork, the business owner begins to operate from a personal standpoint. And sometimes it's caused by situational occurrences. Again, if the business needs a loan and the business has no credit, then the owner steps up and personally guarantees the loan. But that sends out a personal signal for number one. And number two, there can be no limited liability as it relates to that debt. Because if there's a default on that debt, because by guaranteeing, acting as guarantor on that loan, you just waived limited liability protection. So those are some of the things that the business owner needs to be mindful of. And again, that's where the layering structure comes in to play. So here's the other side. We realize that with the LLC, the single entity, with the LLC, if we're operating and we're not mixing money, signing in a personal capacity, or absorbing risk, if the business entity causes harm or injury to someone and a judgment is rendered, then the business owner's personal assets are going to be safe. If you're operating properly, you have the LLC, you're documenting decisions, you're not commingling money, you're not signing in a personal capacity, your personal assets will be protected in the event that a judgment is rendered against the business. But that doesn't protect the business assets. The business assets remain exposed. And here's why. This is when we talk about that single entity trap, here's where it comes in. Because you operate out of that single entity and all of the business's valuable assets are titled in the operational entity, that LLC that you do business out of every day, that you service customers and sell products, public facing. We see vendors, clients, employees, all of those assets that are used in the business on the daily and are owned by the business. Those assets are at risk in the event that a judgment is rendered against the business. So here's how that plays out. When the judgment is rendered against the business, you have the option of either satisfying the judgment or those assets can be executed against, seized, and sold in order to satisfy that judgment. Because everything exists right there in that entity. And the LLC doesn't protect against operational liability weighing against the business assets. That LLC only protects you personally and your personal assets. That's all it does. And again, that is not automatic. That is contingent upon you, the business owner, operating properly. Now, many business owners form that single entity and they fail to even separate themselves personally from the business. So now we have double exposure. If you're absorbing risk personally and you're not separate from the business, then we have the potential for exposure of personal assets as well as the exposure of the business assets. So everything is at risk, particularly if there is a catastrophic loss. let's say where the judgment amount exceeds the insurance coverage. Now everything is at risk. If the business owner has been absorbing personal or acting in a personal capacity, signing things in a personal capacity, now both personal and business assets are at risk. That's not the way that it's designed to happen. The layered structure has ownership separate from control and assets, and which is also separate from the operations. That's how it's done. That's the trust, holding company, and operating company model. That's what the layered structure looks like. Everything in its own place. A lot of business owners get caught up in the whole idea of the ownership piece. And when we put it together, when we put the business structure together, the ownership, the name, the personal name should not be on the ownership. That's how we keep the personal assets out of play, by making sure that your name is not on the business. If we look at the Secretary of State's website, most business owners' names are there. It doesn't matter what state you filed in or formed the business in, whether they have anonymity in the public records and all of that doesn't even matter, because that's just there. But when we look behind the curtain, when we look at the ownership, if a lawsuit is filed and those documents are requested, that's where the proof, that's where it all comes out. Because at that point, we can't hide behind anonymity. The structure is going to be revealed, either revealed or exposed, but it is going to come out at that point. Now, here's another misconception. We're talking about most businesses are built backwards. And most business owners are exposed and they're not aware that they're exposed. But the exposure shows up in a variety of different ways. It's not just the courthouse. That's what many business owners fear. That's the first thing that comes to mind when we start talking about business structure. Courthouse. Yes, that is a place where a lot of things get played out. But it also gets played out at the bank, when you apply for a loan. The bank wants to know how the money moves, who is going to be responsible in the event that something goes wrong, who makes the control decisions, all of those things. And it has a bearing on whether or not they're going to ask for that guarantee, whether or not the interest rate is going to be higher, whether they're going to provide an extended period of time for repayment or a shorter period of time. All of those things go into the bank's classification of the business, whether or not the business is personal or separate, whether the business acts independently of the owner or whether the business is dependent upon the owner. Same with investors. They want to know who controls the business. And what about continuity? Can the business survive if the owner steps away? All of those things matter. They matter. And for many business owners, they don't realize that these things matter until they're either in litigation or a loan application at the bank or applying for insurance coverage. If we're applying for insurance coverage, the insurance company wants to know who owns the assets, how are they titled. They're insuring these assets. So certainly they want to know that. Are the assets titled in the personal name of the business owner? All of those things matter, and they're going to be used to protect the bank, to protect the insurance company. If there's exposure, we're going to see greater premium amounts, maybe exclusions on the insurance policies. All of those institutions have their own rules and their own way of looking at things. But the behavior that they're observing is universal. And they realize that nothing's perfect, that things happen, situations occur. So when they're observing the behavior, they're looking for patterns. If you sign a document in your personal capacity once or twice, that may not by itself be enough to classify the business as personal. But what they're looking for is behavioral patterns. If the business or the business owner consistently does things from a personal standpoint, regardless of what's in the paperwork, then those behavioral patterns become repetitious and they begin to be interpreted as the business structure itself. They're going to become the structure. The paperwork is going to become irrelevant. It doesn't really matter. The paperwork is only important to the extent that it remains in alignment with how things are done inside the business. Once the paperwork says one thing and the business behavior becomes repetitive, sending out signals that the business is totally dependent upon the owner, then it's going to be interpreted as personal. Now, many people say, well, I'll just avoid doing this or I'll avoid signing in a personal capacity or I won't mix money. But those things are merely symptoms. They're symptoms of a bigger problem. And the bigger problem is that the structure was not put in correctly from the beginning. There was no layering. There was the single entity. All of the assets are there in one entity, along with the risk. So naturally, everything is going to always fall back or collapse onto the owner. But if you understand, if your structure is put in properly from the beginning, where ownership is separated from control and your assets are separate from your operations, then you not only have the protection from personal liability and your personal assets being at risk, but you have also protected your business assets from any operational risk. That's the total deal in conjunction with the insurances that the business carries. That's asset protection. That's how you protect yourself. Now, again, everybody wants to do it. Everybody wants to do something for themselves. And that's a big deal. And it's a big deal for us at Free Law School. That's actually what we talk about when we talk about the pro sepreneur. You guys may be familiar with the phrase pro se. It's generally used within the context of someone who represents his or herself in court. But that's not what we're talking about. We're not talking about representing yourself in court. The real meaning of the word pro se or the phrase pro se is for oneself. For oneself. And we all are familiar with the entrepreneur, the person who operates his or her own business, works for themselves. And so the pro sepreneur is that entrepreneur business person who wants to take responsibility for his or her own structural literacy, understanding the environment in which the business operates, understanding how to move. Because once we install the structure, you still have to understand how to maintain it. Remember what I said earlier. Limited liability protection is conditional, and it's conditioned upon the behavior, how we move. So, merely having paperwork in my 30 years of practicing law, I've been to court so many times with business owners or represented business owners or had consults with business owners who were convinced that they were protected merely because they had paperwork. Paperwork is not protection, nor is the filing event, the formation of the business entity. That is not protection. That's just compliance. That means all it's saying is that you have performed the minimum requirements necessary to be recognized by the system. That's all it says. It doesn't address the question or issue of what happens when something goes wrong. It doesn't. So the corporation, the LLC, provides you with the container from which to operate. The container by itself is nothing. It's all about what's inside the container, how you sign, how you move money, documenting decisions, successions, how authority is transferred. Those are the things that matter, and those are the things that support separation. In addition, those entities, those layers interact with each other. There are relationships there, assets being used on the operational level but are not titled in the operational company needs to be reflected by leasing and licensing agreements. We need to know that. We need to understand those things because when we find ourselves, let's look at the institution, the most feared institution, the courts. When we're there, the other side has one purpose after the determination of liability has been made. Then their purpose shifts. It shifts to demonstrating or attempting to demonstrate to the court that there is no structure, that there is no separation between the owner and the business. That's going to give them a greater or broader array of assets to seize and to satisfy the judgments. Basically, demonstrating or attempting to demonstrate to the court that your structure is a sham, even though you have paperwork. That's not real. Let's see the documentation that supports the relationship between the control mechanism and the operational mechanism, i.e., your holding company and your operating company. There are relationships there. So we can't just come out with a sheet of paper and say it is what it is and expect no one to challenge it. You have to be able to support it. And that's what we're talking about the pro sepreneur, taking responsibility for understanding those things on your own, because the business owner is making decisions and making moves on a daily basis. When you outsource your structural literacy or formation, because it's not even structural literacy for many business owners, because they're only now becoming aware that there is a need for more than the single entity. So many of them have outsourced that whole formation piece, right? Thinking that it meant protection. But nobody's ever sat down with you and explained what you need to do to actually keep things safe, to keep things separated. And that's why you need to understand these things for yourself. And that's what the whole pro sepreneur movement is all about. Look, I was doing something, guys, about, again, I practiced law for 30 plus years. And I was only made aware of this, what I'm about to share with you guys. Maybe you guys might know it. But I only really was made aware of it or thought about it about 2 years ago. I was reading an article from the American Bar Association, and they were talking about the demographics, the membership in the bar. And actually, they had been keeping this information since the 1800s. Now, I don't know how many of us there were practicing law in the 1800s, but here's the thing. There is about there are about 4%. 4% of the bar is African American attorneys. There are 1.2 million licensed attorneys in the United States. Now, that's what I was surprised by. I had never really given it any consideration, nor had I ever encountered anything in print saying that fact. But I was reading this article. So there were 1.2 million licensed attorneys in the United States, African American. Well, 1.2 million. 4% of that 1.2 million is African Americans. I looked at the numbers, can't tell you what they are right this minute. If we got a mathematician out there, put it in the chat. 4% of 1.2 million. And mind you, that number is dropping. I think it's 4% right now. It was 5 at that time, 2 years ago. Today, it's 4. The number is dropping. And so that was kind of alarming to me. And thinking back to a lot of the people that I represented, that I encountered, that I sat and watched in court as I may have been waiting for my chance, my opportunity to go up and argue a case, sitting there watching people become aware of their exposure. That's when it occurred to me. And again, the clients and business owners who never really took responsibility for understanding this stuff. You really have two choices. You have two choices. Number one is the traditional choice. That is to hire a lawyer. But most business owners skip the legal part for a variety of reasons. I've heard many of them. Some people say, I don't particularly like lawyers. I don't particularly like talking to lawyers. I think they are too expensive for what they do. Whatever the reasons, many business owners consciously skip the legal. Some do it, I think, out of ignorance, not really being aware of the risk. So I started thinking about what are some of the things that the business owner can do for themselves. And this is something that most business owners can understand and do for yourself. You understand how to manage your personal money. You do that. You manage your personal business on a daily basis. Now, where you got the knowledge from, I don't know. But I honestly believe that there are many business owners who can understand how to maintain their structure and understand what it takes to install it properly with some guidance. Many of you guys do it on a daily basis. You're out there Googling things and talking to AI and all of this stuff like that. What you really need is a reliable source of information and instruction on putting your structure together. And it's so important to do it from the beginning. Here's why. Once the risk arrives, if there's a lawsuit or credit default, demand letters are moving back and forth, then it becomes very difficult to move assets around because that's what we're really talking about structuring. The overwhelming majority of you guys have all of your assets in that LLC right here, right now. That's the built backwards part. That's the single entity trap. And if you're fortunate enough to understand how to operate properly and keep your personal assets separate and safe, your business assets are not safe. They're at risk. And that's actually what you're making the money with. So if there's a claim that results in a judgment and those assets are seized and sold in order to satisfy that judgment, then how do we do business? How do we continue? So it is within your, well, some business owners, because this conversation is not for everybody. Some people become aware and they choose not to do anything with the awareness. Some of the things that I said tonight may have created a level of discomfort. If it did, consider that as awareness. That's awareness. But it's important that we structure prior to any of those pressure events showing up, the litigation, the partnership conflict, employee disputes, contract disputes, any of that, personal injury, any of that. Because once those things show up, we're pretty much precluded from moving assets. Generally, if you attempt to move assets or restructure at that point, the court is going to unwind those transactions as fraudulent transfers. Here's what I mean by fraudulent transfers. The court is going to after the other side cries foul, the court is going to interpret those as done for the purpose of preventing the claimant or judgment creditor from being able to seize those assets and satisfy the judgment. That's how they see it. So you're basically locked into a status quo. If you're unstructured and you find yourself in a stress event, particularly litigation, you're going to be locked into that status quo until that is resolved. And if it judgment and liability is either placed on you or placed on the business, then those assets are exposed and at risk for seizure and sale. That's why it's so important that we put structure in place from the beginning. Because when the structure is installed properly and the entrepreneur founder understands how to operate on their own, they're actually structurally literate, then it doesn't matter how deep things get on the back end, per se. If everything is structured, there are no assets exposed at the operational level. Control and assets exist at the holding company level, and ownership sits above all of it. And the business owner knows how to operate. The documents support it. Then, when the judgment is rendered against the business, the only thing that's at play, at risk, is the operating entity. And the operating entity owns nothing. It should own nothing. No assets, no cash reserves. The only thing that's there is that certificate with the gold seal from the Secretary of State's office and maybe a few dollars in operating cash in that account. So when the judgment is rendered and they go through their entire process of trying to demonstrate that there either is no structure or that the structure that purportedly exists is a sham. Once they go through that process and everything holds, then the only thing the business owner stands to lose is that entity. So the entity gets dissolved and we form another one. The assets are all safe. That's how structure, that's what limited liability protection is all about. But it's important that it be in effect before the pressure event arrives. Now, if you're getting ready to launch something, then this conversation, I presume, has been good for you because now you know that business structure is more than just forming a business entity. It's more than just forming an LLC or a corporation. And that paperwork is not protection. You're clear on that. If you're already operating an entity, there's two different types of founders or entrepreneurs here. If you're already operating an entity, either you're operating from that single entity where both assets and risk exist in the same entity. So there is business asset exposure from the operational risk at a best case scenario. And at the worst case scenario, you're operating out of that single entity and the behavior, business transactions, and business activity is not separate from the owner. And therefore, the owner's personal assets are at risk, as well as the business assets at risk in the operations. So now, for those individuals, there's both business and personal exposure. The second, the second profile, business profile, is the business owner who's operating a business, but who may have formed multiple entities previously. But even if when we form multiple entities, many times the business activity drifts away from what's in the paperwork, from the operating agreement, right? That internal rule book, or from the bylaws, if we have a corporation. Remember earlier we talked about sometimes situations occur where the owner has to step up and fill a void. Those things occur. So even if there are multiple entities, if the business owner implemented a structure, there is the need to go back and reevaluate that to determine where that structural drift may have occurred and where there is the potential leakage in the structure, because you want to find this out and fix it prior to the risk event happening. Now, structuring the business, if there is no structure or some structure, but not the three layers that we talked about earlier, it doesn't require dissolving any businesses. It doesn't require starting anything over. It doesn't require sacrificing employer identification numbers. We get those questions a lot from people who are doing government contracting. Those numbers are very important as they're tied to the contracts. There's no need to do any of that. We come in and we teach you and walk through step by step with putting the structure in place and supplementing in all those areas where you're deficient. That's how it's done. Now, it doesn't erase history, but if there is no pressure event, litigation, conflicts, then it's fine. Once you install your structure properly, then any event, any risk event that occurs going forward, it's going to be determined, the classification is going to be determined based upon how the business moved going forward from implementation of that structure. Even though most businesses are built backwards, if you become aware, and that's what we're talking about, that's what we're doing, and you take action, then it doesn't have to become a fatality. It doesn't have to become a fatality. And I know that it just goes against the reason you guys don't know is because there is not a significant desire for attorneys to sit down and say, we're going to tell you how to do this. We're going to tell you how to keep yourselves safe. That's the purpose. And if we're talking about wealth building and legacy, it's important that you understand these things in order to pass that knowledge and understanding down to the people that you're actually putting it all together for, the people that matter for you. You have to pass that information along to them. Once you put it in effect and once you understand how it works, it's done. It's like putting the foundation in on a building. You only put the foundation in one time, but it's important that you install it correctly. That's it. So, but again, going back to the profiles, if you installed some business structure, if you have multiple entities, then you need to look at where there might be drift in your operation. And for those individuals, I put together a 5-point structural exposure check. The link is in the description. You can go to the description here or description in any of my YouTube videos. You're going to see it. It says structural exposure check. There's no charge. It's free. Take the check and see where the exposure is in your operations. And it's not only for the business owner who installed or created multiple entities, it also works for the business owner who's operating out of the single entity, because it is going to tell you whether or not you're protected from a personal standpoint. It's going to tell you whether your personal assets are safe. And when you're taking the exposure check, you need to answer the questions from the standpoint of how you're actually operating right now. Not from an aspirational standpoint, not from the standpoint of, how you think the question should be answered, because then you're not going to have it, it's not going to give you a truthful evaluation. You need to be honest about how you're actually operating. And at that point, once you do the structural exposure check, if you're inclined to do something about your structure, if the idea of the pro sepreneur appeals to you, if that sounds like something that you'd like to have as a part of your understanding, then send me a message. The links to my social media, is also in the description. You can send me a message on IG or LinkedIn. We are Free Law School everywhere. So I appreciate you guys tapping in tonight. And we'll see you in the next conversation. And have a great weekend.